advice.
Good morning, everybody.
With your questions, 877-850-8585.
That's the number to call in.
850-8585. Now here's your host, attorney Jeff Vastola.
Good morning, everybody, and thank you so much for tuning in by radio or by Facebook Live. I'm Jeff Vastola, your host. I'm here every Saturday morning to give you free legal advice. Just about every Saturday morning when we don't have technical glitches and when we don't have vacations getting in the way. I was supposed to be out of town next Saturday out in Colorado, but the trip got canceled. So I suspect I will be here giving you free legal advice next Saturday as well. You can call into the radio show with any questions at all. That number is 877-850-8585. Or if you have a question that you'd like to talk to me about in private, you can dial my cell phone, which is 833-VASTOLA, 833-827-8652. That's the number to get through to my cell phone. If you have a case that you want to discuss with me to perhaps hire me, use that number. If you have something that you'd like to talk about which doesn't pertain to personal injury, wrongful death, medical malpractice, that kind of a thing, but it's just too personal to share with everybody on the radio or on Facebook Live, then feel free to use that number and I'll be happy to talk to you. It is December 26th. I'm wearing my Merry Christmas shirt today. Merry Christmas to everybody, and Happy Hanukkah to those that celebrate Hanukkah. I know it's over, but Happy Hanukkah and Happy Kwanzaa, and but Merry Christmas to everybody, and especially this year, let's remember the reason for the season, as they say. You can find out more about me and my law office if you're interested by going to my website at www.vastolalegal.com. Vastola is spelled V as in Victor, A-S-T-O-L-A. And you can follow us on social media. I don't do a whole lot of that at the moment. Kind of comes in waves. But I have, of course, Facebook, Instagram, Twitter, YouTube. We're on LinkedIn. If anybody's a professional and you want to reach out to me on LinkedIn, feel free to do that. And as always, reach me Monday through Friday to talk about personal injury or wrongful death claims. It's really what I do. One of the things I'm going to talk about today are product liability claims. And the reason I want to talk about that is because I've seen some articles where big pharma companies are going to be given a complete hall pass to any liability for COVID-19 vaccines. And, you know, thankfully, companies are working hard to try to figure out how to curb COVID-19 or perhaps get rid of it entirely. The problem is if they don't have the time, which clearly they don't have the amount of time that they would typically put into a vaccine, then it can be incredibly dangerous, and everything is essentially being rushed. And good morning, Patty. Nice to see you this morning. Hope you're doing well. So that's my concern. My concern is with a vaccine that's incredibly rushed, and to suggest we want complete immunity for anything that this vaccine may cause, significant harm, even death, then that's fine, but where's the quid pro quo? If you want the quid pro quo, then perhaps you should be making the vaccine free to the public. If you want complete immunity, obviously there's tremendous cost in developing the vaccine, so I'm not ignorant to that, but to suggest that big pharma should be able to make how many gazillions of dollars is the first company going to make that comes out with the COVID vaccine, to be able to make that much profit and have absolute immunity, to me just doesn't sit well. And perhaps that's why I'm a plaintiff's lawyer and not a defense lawyer, because otherwise it just seems to be incredibly and entirely unfair. So Patty's typing in that the vaccine is free at the moment. I guess buyer beware, right? If you're going to take the free vaccine, and for how long will it be free, I guess is the question. But anyway, be aware of the fact. Now, I'm also not ignorant to the fact that there's a federal law suggesting that Big Pharma has immunity already from vaccines dating all the way back to, I believe, 1998. So there's significant protection on the books already for Big Pharma. But one of the things that really stuck with me when I was in law school was in my torts class, and again, torts is any kind of a civil wrong, we learned that lawyers have developed over the last 100 years or so, possibly even more, as gatekeepers of public safety. The lawyers, the plaintiff's lawyers specifically, are the ones that keep the big companies in check. When they create dangerous products that harm people, it's the plaintiff's lawyers that bring the lawsuits to bring them. It's a system of checks and balances, kind of like government, but in this instance, it's liability. It's liability checks and balances, and that's something that really clicked in my head when I was in law school, and probably one of the reasons why I'm a plaintiff's lawyer today. I like the issue of accountability and making sure that, you know, the big companies just don't run away over taking advantage of the health of us. So I'm here for us, in a sense. I'm not just going to be talking about product liability today. I'm going to be talking about a whole bunch of cases that I found in my Florida Law Weekly. Really interesting reading this week, at least for me, law nerd. And so I'll be talking about those things. But I want to emphasize the number again. If you'd like to call into the show, dial 877-850-8585. I do prefer to take phone calls instead of just talking for 30 minutes. And if you call in with a question that I find interesting enough, it could become the topic of the day for the following week's program. Now listen, if you call in and I don't know the answer to your question, then I personally obligate myself to do the research so that I can give you an educated response to your question the following week. I will upload all of these videos and the audio to our YouTube account and also to our website, so you can find these videos in a library later on. You also are supposed to be able to find these videos in the 850 AM library. 850 is the station, of course, that airs the show every week. So lots of different places that you can go. If you miss a show, if you were expecting to get your answer on a given Saturday morning and you just weren't available, you can go to the library to listen to the entire audio, or if you want to watch Facebook Live, you can watch that as well. And you can get the answer that perhaps you missed. And you can, of course, always just reach out to me at 833-VASTOLA and call me. If you have a question about personal injury or wrongful death, product liability, those are the types of cases that I handle Monday through Friday throughout the week. So feel free to reach out to me and talk to me about any of those cases, okay? So I just want to ask everybody again that's been praying for my dad to please send up an extra special prayer today, if you would. We're not having a good few days, so we appreciate all the prayers that we've been getting, and please keep them coming. We appreciate it. So let me talk about some of these cases in here. And sometimes I talk about the case because I find it interesting from a legal perspective, and then sometimes I talk about the case because it's interesting from a factual perspective. This is a case that's interesting only, I think, because of a legal perspective. It was a quiet title action, which is somebody trying to eliminate somebody else's claim on a real estate interest. And in this case, they were alleging that their signatures were forged on a document that gave the other party an interest in real estate. And what's interesting is that the trial court agreed with the plaintiffs, or the parties that were saying that their signatures were forged. However, procedurally, the problem was that they did not raise that defense. That has to be raised as what's called an affirmative defense, and you have to actually litigate the issue. You have to give the other side essentially fair notice that you're going to be defending on that claim. And although the trial court conceded that it was never raised as an affirmative defense, the trial court essentially went on the premise that it was still litigated. And that's when you go to trial on an issue that has not been pled in the pleadings, those are the documents that are filed with the court, then you can try the case by consent. If you raise the issue, the other side doesn't object to it, the other side makes arguments in response to it, even though it's not literally in the paperwork, it can be tried by consent. And that was the argument that the trial court made here, to say, well, yeah, they alleged that it was a forgery, and then they went on to make all these other arguments about how they were tricked and deceived into signing, which is completely different than somebody saying that signature is not mine, it's a forgery. At some point in the trial, the husband admitted that yes, it was his signature, but he believes he was tricked into signing something and was deceived. And so the trial court said, well, the issue was tried by consent. Well, the appellate court said, after reviewing the entire record, said no, it was not tried by consent, and so the appellate court was wrong, and so they sent that case back. It was reversed back to the trial court level with instructions, remanded with instructions to enter judgment in favor of the other party, because essentially the parties suggesting initially forgery and then changing their story to suggest that it was by trick deceit, they essentially lost the case because they did not plead it properly. So if you're interested, that's a case of JAK Capital versus Katrina and John Adams, and that was based out of the 2nd DCA, which is over in like the Naples and Tampa area, Southwest Florida. Anyway, that's, like I said, interesting to me just procedurally because of how things were pled and specifically not pled. Good morning, Andy. Nice to see you. Merry Christmas. For those of you that want to call in with a question of your own, if you have follow-up questions to any of these cases I'm talking about, dial 877-850-8585, or you can just type into Facebook Live and we can chat. Here's another case I I talked about one of these cases a week or two ago. It's the electronic footprint that criminals tend to leave behind, and they don't even realize they're doing it. And oftentimes it's with your cell phone. That's the most common way to leave an electronic footprint somewhere. But you can also leave electronic footprints with your vehicle and probably your computers, your iPods, your laptops. I would imagine you're leaving electronic footprints with those as well. But this is a case where the state of Florida was prosecuting an individual for first-degree murder because they went into a restaurant after it had closed. They kind of broke into the back door, and there were 6 people in there, I guess kind of closing up the restaurant, cleaning up, things of that nature, including the owners. And the boyfriend of one of the owners is the one that had gone to the door to, I guess, bring garbage out or something like that. And the criminals came in when he opened the door and shot him, unfortunately, very regrettably, and he was killed. And so these assailants were masked, so they weren't specifically identified, but using cell phone data, they were ultimately able to get a prosecution and for first-degree murder. And what happened was the defense attorney for the criminal raised the issue of what's called a Daubert challenge for the expert who took the stand. It was basically the police investigator who took the stand to talk about this electronic footprint that was left behind by this assailant's cell phone. And what's interesting to me about this case is that very recently Florida has adopted this, what's called a Daubert standard, where experts, if they're going to testify, have to be able to testify that any and all scientific testimony or evidence admitted is not only relevant but reliable. And the trial judge is the gatekeeper, and the trial judge must make a preliminary assessment of whether the reasoning or methodology properly can be applied to the facts at issue. And then the Daubert case itself lists several different factors that the court can take into consideration, but the court's not limited to those factors when deciding, is this expert qualified to talk about the things that he or she wants to talk about? In this case, the expert was a police investigator who was talking about the cell phone program where cell tower data is downloaded and utilized to be able to identify where somebody is, and at a specific point in time with their cell phone. It's called TRAX, T-R-A-X. And although the expert testified at the Daubert hearing that he was not sure of the algorithm that the computer software program utilizes so that it will work, he testified that he's had over 100 hours of training in cell phone mapping and analytics. He's been involved in 200 cases involving cell phone mapping and analytics. He's testified in more than 10 cases in Palm Beach County. This is a Palm Beach County case, by the way. Very unfortunate that it happened here locally. But it's unfortunate that it happens anywhere. It just it happens to be very close to home. And so utilizing all of this criteria, the trial court, Judge Joe Marks, who I happen to know, good morning, Judge Marks, properly ruled that this investigator was qualified to testify about cell phone mapping. And using that information, the jury convicted with a first-degree murder conviction, among other things. And so this person who was involved is going to spend a significant amount of time behind bars, hopefully along with the other assailants, because there were 2 or 3 assailants that barged into the restaurant and shot the man. Next case. This is interesting, I think, factually and from a legal standpoint. This has to do with disposition of remains. When somebody passes away, there is a Florida statute that governs how the funeral homes are to deal with certain, family members and that kind of a thing. And this particular case, which is Guyette versus Cy Funeral Services of Florida, again, another Ford DCA case, but this is down in Broward County, involves an individual who died in a plane crash very recently, August 28th, 2020. This person who was at issue died in a plane crash. He left behind a widow, and he also had a son, an adult son. The widow arranged for cremation at Menorah Gardens, and the son immediately got involved to say, wait a minute, my dad told me all the time that he wanted a formal Jewish burial, and so we can't have him cremated. And so you've got the widow and the son fighting over what should be done with the decedent, the man that died in the plane crash. And the widow immediately, so the son filed something in the court system saying, we need to hold off on cremating my dad, because if you do that, it's going to be too late. And the widow responded to say, well, I was with the man for years, and she testified in her filings that her husband was not religious, did not regularly attend temple, and actually had expressed disdain for religion. She went on to say, however, that she herself practices Judaism. So this is not an issue where you have competing religions. This is an issue where you just have the Jewish widow doing what she felt her husband wanted her to do, but you've got then the adult son who says, no, my dad told me all the time that he wanted to follow a formal Jewish burial. The reason the case is interesting to me beyond that, beyond the facts, is because I learned something as I was reading about this case, and it states, it makes reference to 2 different Florida statutes. First, it talks about Florida Statute 497, specifically .005, which lists legally authorized persons and their priority. And it specifically does give priority to the widow over adult children. However, the court went on to say, the trial court went on to say, because we believe the widow has priority, we're going to go ahead with her wishes. The issue was immediately appealed to the 4th DCA. Remember, this person died in a plane crash August 28th of 2020. You can see the wheels of justice are turning very quickly in a situation like this. And the appellate court said, well, we understand why the trial court focused on that particular statute, but that's the wrong statute. That's the statute that deals with, that specifies how a funeral home is to deal with a certain customer and who has priority. But the focus here is not on the funeral home. The focus here is on the decedent and what his wishes were. And so the opinion goes on to say, Florida law has long recognized the rights of survivors of a decedent regarding the burial and disposition of the remains. In Florida, there is a legitimate claim of entitlement by the next of kin to possession of the remains of a decedent for burial or other lawful disposition. These rights to a deceased remains, however, exist only for purposes of burial or for other statutory purposes and nothing further. So even where a provision in a will concerns the burial of a decedent's remains, we have held that the issue of burial location is a factual question which may be submitted to the court. So basically, the appellate court got involved immediately and said, who wins here, the widow or the adult son, is going to have to be an issue of evidence to be presented to the court. And that's not found in the statute, that's found in common law. And if you've watched my show before and you've heard me make this explanation, you have to understand that the laws we live by are found in different places. You can go to the Florida statutes. In the old days, you used to have to go to a law library to find the books. Nowadays, you can go to Google or any other search engine and type in Florida statutes, and you have complete and direct access to every law in Florida in the form of a statute. But statutes are not the only law. You can have also common law, which is the law that has been created by the courts over time, the judges that are making decisions, and then the appellate courts that either affirm or deny them. Ultimately, the grand authority in Florida is the Florida Supreme Court. Over time, the courts can also make law, and that's called the common law. And sometimes you can have, not very often because they do try to make things consistent, but sometimes you'll have a statute in place and also common law in place, and they might seem to contradict one another, which is almost precisely what was happening here, except the appellate court pointed out to say, no, we're not really contradicting the statute. The statute's focusing on the crematory, Menorah Gardens. We're focused on the wishes of the decedent. And so they use the common law to say you basically need an evidentiary hearing. The judge, the trial judge, is going to have to have evidence, call the parties in, have them present their evidence, and the judge is going to have to make the decision as to whether this decedent gets cremated or gets buried. And so very interesting for me, anyway, from a legal standpoint, because now you've got a third party who didn't know the decedent, who's going to make the decision as to how he should be, what should happen to his remains. So, in a sense, you would almost want the widow and the adult son to get together to say, look, let's try to work this out. Let's talk it through to say, okay, who spoke with him last? What's in his will? And in this particular case, there was nothing in the will, but, maybe try to work it out amongst yourselves, because otherwise the trial court is going to get involved and it's going to be the tiebreaker. So, let me see. There's another case legally interesting to me because it has to do with a lawyer's comments during closing argument. It's about 7:54. I can't believe I've already been talking for almost 30 minutes. If you'd like to speak with me about a case that you think you may have, call me at 833-VASTOLA. That's 833-827-8652. You can go to my website to find out more about me and my firm, vastolalegal.com. And while I'm running out of time, I want to talk to you about this. But one of the things that most people don't understand is that there are a lot of rules. There are a lot of rules that constrain a lawyer on both sides of the case to what can be said during closing argument. There's what they call the golden rule. The golden rule, at least with regard to closing arguments, is you never ask a jury to place themselves in the shoes of the plaintiff. You just can't do that in the state of Florida. That's reversible error. Another thing as a plaintiff's lawyer that you can't do in closing arguments is you can't ask a jury to use or to be swayed by sympathy. Now, that's a little contradictory because, hey, good morning, Don. I see you this time. In the voir dire process, where we're picking a jury, the selection process of asking jurors questions and everything else, you can talk to them about sympathy, and you can talk to them about, when they're selected as a jury member, they can come in with their life's experiences and all of their emotions, including sympathy and all these other things. But at the end of the case, the judge is always very clear to give an instruction to say that they are not to be swayed by sympathy. And so what this lawyer did in the case of State Farm versus Knapp, this is a 50 CA case, so this is Central Florida, the greater Orlando area, and I'm sure many surrounding areas of that. The plaintiff's lawyer, instead of using the word sympathy in closing argument, suggested that the jury use empathy. And I would imagine there was a reason for that. Oftentimes, in a personal injury, this was a personal injury case, car accident. I can tell it's a very brief opinion. It's only that long. But I can tell from the facts of what's written that this was a car accident because it has to do with uninsured motorists. But typically, when you have a jury selected for a car accident case, there's usually at least one out of the 6 or 7 people that are chosen that have been involved in an accident, or they know somebody that's been involved in an accident. And so this lawyer, in his own mind, I guess, decided very cleverly to use the word empathy instead of sympathy, because the jury instruction specifically uses the word sympathy. Well, plaintiffs won. It doesn't tell us how much they won, but we know that State Farm appealed the final judgment, which means the plaintiffs must have won the case. And in their appeal, State Farm said, well, they violated one of the canons of closing argument by saying that the jury should not be swayed by sympathy. Yet the plaintiff used the word empathy instead. And the opinion basically says, it's kind of a slap on the wrist for the plaintiff's lawyer, saying, don't be so cute next time. You know you're not allowed to do that. But they found no error in what the lawyer did, the plaintiff's lawyer, so they basically denied State Farm's appeal from that point forward. And State Farm theoretically could get the attention of the Florida Supreme Court so that it might go higher than this, but I doubt it. I think that's probably the end of the road. State Farm is probably going to have to pay whatever it was ordered to pay by the jury, and then what the jury renders is a verdict. It's a piece of paper that says this is what the plaintiffs are entitled to, in our opinion, as the jury. Ultimately, that jury verdict is reduced to what's called a final judgment. But the final judgment, how much longer, Serena?
A minute.
1 minute. Oftentimes, the final judgment is never the same amount as the verdict because there are oftentimes trial offsets, either things to be taken away from the verdict or things to be added to the verdict. That's called an additor. But thank you so much for paying attention and watching me or listening to me this morning. Merry Christmas to everybody again. And please, extra strong and special prayers for my dad. He's not doing very well, and we really appreciate all those prayers. Thank you very much. God bless to everybody. Have a great week.